IMS RTI Club. The main objective of providing the information is not only to promote openness, transparency, and accountability in the administration, but also to ensure the participation of people in all the matters related to governance. Now, to begin the session further, I would like to call upon our respected Dean Academics, Dr. Manju Gupta ma'am, to share her words of wisdom.
Thank you, Pratiksha. First of all, I congratulate to School of Law for organizing this event under IMS RTI Club. And foremost, I would really congratulate Mr. Madan Lal Sharma, who is gracing the occasion today and sharing their views with the students. Mr. Sharma is a very big personality in terms of their own field. I mean, he has done so many jobs in various public sector and private sector, majorly into public sector. He was a member of Indian Police Service for 36 years. In the capacity, he has various field positions. Mr. Sharma also served in the Central Bureau of Investigation for 18 years in various capacities, and he was the head of banking, security, and fraud cell for almost 4 years. So we are very lucky and fortunate enough that we are getting chance to hear from this, mouth, because this is really, really very great opportunity for the students of IMS Law College, and of course for IMS fraternity and faculty members who are getting chance to, learn from the, wisdom of sir, and of course his great experience will be enlightening us today. After retirement from CBI, Sir was the special director. He was appointed the CII, Central Information Commissioner from 2008 to 2013, and in that capacity he held considerable position and experience in deciding these appeals under the Right of Information Act 2005. Sir has also carried out an inquiry against the former director of Central Bureau of Investigation under the order of the Supreme Court of India. So I'm sure we are really very, very fortunate that we are going to hear this, sir, and he was accepted by the, this plea the report has been accepted by the court, Apex Court, I can say, and criminal proceedings were ordered against the former director. In terms of this subject, if I talk about the topic which we are taking today, webinar on RTI in practice, mapping and mapping the effectivity and efficiency and efficacy of this subject. So basically, citizen RTI is seen as a holistic perspective. It is the cornerstone of all entitlement as access to information leads to securing other entitlements. Exercising the rights, a citizen can actively engage the public authority in securing information on why the problem has occurred, who deals with the problem, and what action has been taken to solve the problem, what action has been taken on past complaints, and how long it would take to resolve the problem, leading to informed choices on what can be done to resolve the problem for realization of entitlement. I'm sure this topic will give us more insight about this subject. And of course, we are really, really fortunate, I'm saying again, that Mr. Madan Lal Sharma is there with us today, and he will enlighten us with his great experience and knowledge. Thank you, sir. Thank you. Welcome, sir.
Thank you, ma'am. Thank you so much for your kind words. Now, today we have with us Shri M.L. Sharma, sir, former Central Information Commissioner. Sir is a postgraduate in economics from the Delhi School of Economics 1971, while also having a law degree from the University of Delhi. Sir was a member of the Indian Police Service for 36 years, and in that capacity, he held various field positions. Sir has also served in the Central Bureau of Investigation for 18 years in various capacities and was head of the Banking, Security and Fraud Cell for almost 4 years. After retirement from CBI as Special Director, he was appointed the Central Information Commissioner from 2008 to 2013. And in that capacity, he has held considerable adjudicator experience in deciding the appeals under the Right to Information Act 2005. Sir is a highly eminent, experienced and qualified personality and is widely invited by the law universities and police training institutions to speak on legal investigation matters, while being a consultant of various firms, companies and individuals in legal and enforcement matters. I request you, sir, to please enlighten us with your words of wisdom.
Good afternoon to you all. Thank you, Pratyaksha, for introducing me to your audience in such glowing terms. Thank you, Dr. Manju Gupta, Dean Academics. for introducing the subject. I must in particular thank Professor Govind Prasad Goyal of IMS Law College to have contacted me for this webinar, to which I readily agreed. In fact, I started my career as a lecturer in Shri Ram College of Commerce in economics in 1971 after passing out from Delhi School of Economics. But as the chance would have it, I didn't stay long in academics, in the sense that I appeared in the competitive exam that year and qualified first time for the IPS and joined it in 1972. But the literary taste or academic taste still continues with me. My wife was also in the teaching profession. Later, of course, she rose to be a high-level scientist. My daughter, Dr. Gunjan Sharma, is presently in academics. She is teaching in one of the economics in one of the Ivy League universities in USA. My father-in-law was also an academician who studied in Cambridge. So when I'm saying all this, just to underline the point that when I get invitation from academic people to talk on subjects about which I know a little, I have no hesitation in accepting these invitations. And that's what brings me face to face with you. I had a brief talk with Professor Goyal a short while ago, and he told me that I'm supposed to speak to you for about 35-40 minutes, whereafter the session will open for questions and answers. I'll try my best to make the best of time placed at my disposal. I have written a book on the RTI, which is going to come out in about a month's time. And the subject of the book is the right to information and its jurisprudence. It's a unique book of its kind in the sense that I have tried to consolidate the judgments delivered by constitutional courts, that is the high courts in the country, the Supreme Court of India, and the Central Information Commission in this book, with my comments on them. So I can do no better than start with the opening page of my future book, that is first chapter, first page, RTI, the global perspective. So I'll read out very briefly about 10 lines, 20 lines from that book, and then I'll cover various aspects of the RTI. The scheme of my lecture is going to be something like this. First, introductory remarks, then RTI in the global perspective, then evolution and growth of RTI in India, and thereafter salient features of the RTI Act. I'll very briefly speak about this also, because even though I presume that being law students, you have read the Act and you know all about it, yet to give a perspective to the talk, I like to briefly dwell on that. The last and most important would be the implementation of the law, that is RTI Act in this country, which you call mapping its efficacy and effectiveness. So, as introductory remarks, I should say that the Parliament of India enacted the Right to Information Act on 15 June 2005. It came into force on 12th October 2005. The experience of its implementation during the last 50 years has amply demonstrated there's the most transformative and revolutionary law that a parliament has ever enacted in the post-independence era. In fact, this law is citizen-friendly and recalibrates the relationship between the citizen and the state and endeavors to place the governed at the same pedestal as that of the government, functioning through its instrumentalities. The underlying philosophy behind this act is to strengthen and deepen participatory democracy, which is the key to good governance, which in turn is essential to bring about an improvement in the quality of life of the citizenry. Good governance essentially has four attributes: transparency, accountability, predictability, and participation. The RTI Act is an effective instrument of good governance. The preamble to the Act at the very threshold states that its aim is to promote transparency and accountability in the working of every public authority and to create an informed citizenry through transparency of information with a view to containing corruption and holding governments and the instrumentalities accountable to the governed. The emergence of RTI Act has a global context. This right to access information from government and its instrumentalities has been incorporated in several international instruments. A number of countries have signed conventions to this effect. In some countries, this right has a statutory status, while in others, it has been elevated to the level of a constitutional right. Sweden was the first country in the world to have enacted the Freedom to Information Law way back in 1766. Colombia followed suit in 1888. After a lull of almost a century, from 1980 onwards, the world has witnessed a competition amongst countries to enact some kind of right to information legislation. As of now, 84 countries have enacted such a law, and several others are in the process of following suit. As I said in the beginning, this law or this right has a global perspective. The United Nations General Assembly resolution of 1946 speaks of right to information. Likewise, Article 19 of the Universal Declaration of Human Rights, Article 19 of the International Covenant on Civil and Political Rights, Article 13 of the UN Convention on the Rights of the Child, 1989, and the UNESCO Declaration of 1978 on promotion of human rights speak of right to information. In fact, they declare that right to information is a universal right. As regards the Commonwealth, the Commonwealth Law Ministers meeting of 1980 also acknowledges right to information. So does Rio Declaration on Environment and Development 1992. Likewise, Article 9 of the African Chapter on Human and People's Rights 1981 deals with this matter and commends this right. Organization of American States have made two instruments. One is American Convention of Human Rights 1969 and another one is Inter-American Court of Human Rights 2006. The European Union didn't want to be left behind, and therefore you also have a European Convention on Human Rights. Thus, you would see across the globe, right to information over the years, last 50, 60 years, has been recognized as a universal right. All these conventions that are spoken of basically recognize certain salient principles as regards this right. And these principles are as follows. One, maximum disclosure. Two, obligation to publish information for public domain. Three, promotion of open government. Four, limited scope of exceptions. Five, processes to facilitate access to information. Seven, or six, sorry, information to be provided at reasonable costs. And then another important principle is disclosures to take precedence over non-disclosure. And last but not the least, protection to be given to the whistleblowers, etc. These are the 7 or 8 principles recognized across the world as far as RTI is concerned. Coming to India, this law, RTI Act, is the brainchild of the Supreme Court of India. Of course, for our Constitution, Article 19(1) guarantees freedom of speech and expression to all citizens, but this right, even a constitutional right, remained dormant because there was no legal instrument to implement it, and therefore the various judgments declared by the Supreme Court, sowed the seed of RTI information. For example, State of UP versus Raj Narayan of 1995, followed by S.P. Gupta versus Union of India of 1981. They were the judgments which recognized right to information. These judgments followed by Ministry of Information and Broadcasting versus Cricket Association of Bangalore, 1995. And then Reliance Petrochemicals Limited versus Indian Express Newspaper, Bombay, Private Limited, 1988. And likewise, a last important judgment delivered by the Supreme Court was People's Union for Civil Liberty versus Union of India, 2004. Now, these were the judgments of the Supreme Court which laid the foundation for right to information. And now, apart from these judgments, popular movement in central Rajasthan, covering districts of, say, southern Udaipur district and Ajmer, Pali, etc., etc. I was SP of some of these districts. I was SP of Ajmer district. I was SP of Udaipur district. Now, the areas bordering Ajmer and Udaipur districts, they were the fertile grounds for this right. It was Aruna Roy, a former IAS officer who was working in these areas, and she started this movement. Her organization was Mazdoor Kisan Shakti Sangathan. Actually, it started off as an anti-corruption movement, but later it became instrumental in the enactment of this law, first in Rajasthan and then across the country. Of course, later many other authorities and personalities joined this movement. Now, I have briefly traced this movement in my book, but if you are more seriously interested in finding the history or reading the history of this movement, then there's a book written by Aruna Roy. It's called RTI story is available in the market. You can go through that, or you can wait for my book. Now I come to the salient features of RTI Act. Section 2F defines information. Information in inverted commas is a inclusive definition and covers almost everything under the sun. Now, what is information? Information, as per Section 2F, is records, documents, memos, emails, opinions, advices, press releases, circulars, orders, law books, contracts, reports, papers, samples, models, and importantly, data maintained in any electronic format. This is information. Keyword in this law is public authority, as defined Section 2H, is only the public authority which is supposed to supply information. Of course, under Section 2F, information can also be accessed from private entities, but that is in rare circumstances. I'll not go into that. So suffice to say that information can be accessed only from public authorities. Section 2J defines what is right to information. Section 2N talks of third-party information. Now, Section 4.1b is the heartbeat of this law that talks of suo motu disclosures, that is voluntary disclosures to be made by the public authorities. There are 7 chapters in this, or 17 topics, on which the public authorities are supposed to place information in public domain even when it is not asked for. And in fact, if we were to succeed in implementing the provisions of Section 4.1b, then many of the problems which have arisen relating to this law, of which I'll talk later, would not be there at all. So voluntary disclosures. Then sections 12 to 17 talk about information commissions. There are 2 sets of commissions. Central Information Commission, of which I was a member. Central Commission deals with those subjects which are covered broadly under the central list. And the second set of commissions is State Information Commissions. Every state has its own information commission. In a small state like Mizoram and Manipur, they have their information commissions. But the union territories don't have commissions. Union territories are covered by the Central Information Commission, as they are deemed to be an extension of the central government. So sections 12 to 17 deal with information commissions, constitution, service conditions, so on and so forth. Now, sections 3, 6, and 7 of the Act deal with the demand and supply of information, like information can be sought under section 6, and it is to be supplied under section 7. As you know, information is supplied in 30 days time. If it's not supplied in 30 days time, then it has to be supplied free of cost. And another important implication is that if information is not supplied in 30 days time, then the public information officer is liable to be fined or impose penalty at the rate of rupees 250 per day. Each day's delay will cost him 250 rupees from his pocket, subject to a maximum of, say, 25,000 rupees. So this is about. Now, the impression generally that goes around is that you can ask for any information under the sun. No, this is not correct. While sections 3, 6, and 7 speak of supply of information or deal with supply of information, sections 8, 9 and to some degree 11 deal with denial of information, which means that everything that you ask for cannot be supplied. It is subject to prohibitions of section 8(1) and also certain prohibitions of section 9 and 11. Now, what are the clauses or what are the circumstances in which information cannot be supplied? I'll quickly run through them. Section 8(1). First, any information which relates to the or which prejudicially affects the sovereignty and integrity of India, security, strategic and scientific and economic interests of the state. Now, Kuldeep Nair, a very well-known journalist, when I was Information Commission, he came to us for disclosure of Henderson Brooks report, about India-China War of 1962. We refused to disclose this information. Of course, he castigated the commission in his book that he wrote later, saying that it's an old matter, it should have been disclosed and all that. But we accepted the Army's position that deployment in the border areas, because of topographical reasons, remains almost the same as it was 50, 60 years back, and therefore disclosure of this information would undermine India's national security interests. And the examples and many other examples is one. Two, information which is forbidden to be disclosed or published by any court. Like these days, names of rape victims, courts say don't publish them. So if somebody asks the name of a rape victim, it can't be disclosed because court orders so say. Third is information which would cause a breach of the privilege of Parliament. Privilege of Parliament remains undetermined and undefined in a precise manner, but we have to make sense of the circumstances and decide whether it's to be disclosed or not. Information which is of commercial confidence, trade secrets, or intellectual property cannot be disclosed. Likewise, information which is given to you in fiduciary capacity. You are law students, you know what is fiduciary is. Fiduciary and beneficiary. I file my income tax return. So my returns are stored or kept or supposed to be kept in confidence by the income tax department. They are not to be disclosed in ordinary course unless there is overriding public interest. So further, information which has been received in confidence from a foreign government can't be disclosed. Information disclosure of which would endanger the life of a person cannot be disclosed. Like police run sources, mukhbir. So name of mukhbir cannot be disclosed. Otherwise, he would be killed. I worked in the CBI of 20 years. I know people were killed even for non-disclosure of information on the mere suspicion that they would have disclosed information. So this cannot be disclosed. So another clause is information which would impede, word is impede, the process of investigation or apprehension of criminals. Investigation or prosecution. This cannot be disclosed. Cabinet papers cannot be disclosed until a decision has been taken. And last and most important is private information cannot be disclosed. Now, what is privacy? And privacy is now a fundamental right. Puttaswamy case is the latest one. But, in anticipation of this privacy law, I had passed a very significant order. This was Girish Ramchandra Deshpande, here a senior lawyer from Bombay, all the way from Bombay, appeared for me, and he wanted me to disclose certain personal information relating to a public servant who perhaps would have troubled the business family, particular business family or something. So I refused to disclose personal information. What is personal information? They wanted to know his assets, movable assets and immovable assets, whether he had been issued any memos, whether he had been punished, whether department action had been taken against him, and so on and so forth. So I refused to disclose that. So against my order, they went to single judge of the Bombay High Court. He upheld my order. Then went to a division bench. Division bench upheld the order. Then ultimately they went to Supreme Court of India, and this case is known as Grish Ramchandra Deshpande, as finds a very prominent place in my forthcoming book. So Supreme Court also upheld my order. Of course, it was anticipation of Puttaswamy and all that. So without specifically saying, this section 8.1J or clause J of section 8.1 recognizes right to privacy. Now, copyright is protected in section 9, but this copyright has to be of individual, private person, not of the government. Government copyright is not to be protected as per RTI Act. I give you a case, Metro Pillar 66, which collapsed many years back. So one particular architect came and he wanted the disclosure, the design of the pillar, which had collapsed, in which so many people had died, laborers and all that. So I decided to disclose this information. This matter also went up to Supreme Court and my decision was upheld. Now, my basic logic was this, that of course, Delhi Metro has invested money in the designing and building of this pillar, but its design is a failed design. That's why the pillar collapsed. Nobody is going to benefit from it. Rather, and therefore, there is absolutely no harm disclosing the design so that such design is not repeated in future pillars. So this was the logic. Third party information. What is third party? I am an officer in the government. So some people have written my ACR. Now a third party comes and wants to have a copy of my ACR. The law is that the public information officer has to issue a notice first to me, and they'll ask for my views, whether I have any objection to disclosure of this information. Obviously, I'll say whether it's ACR or income tax return. I'll say no. If it is no, then my no is not binding on the public information officer, but public information officer cannot do it on his own without seeking my views. Section 18 provides for complaint procedures. It's complicated. I'll skip. Section 19 applies for, deals with appeal procedure. Now, it's a three-layered structure. One is the CPIO, Central Public Information Officer, or State Public Information Officer, as the case may be. If you're happy with the decision, matter ends there. If you're not happy, then there's a first appellate authority. He is senior in hierarchy, and you file an appeal, and you try to get information which has been denied to you. If you're still not happy with his decision, then at the apex level, second appeal is to be filed for the Central Information Commission or State Information Commission, as the case may be. And the information commissions are the final authorities in the matter. You can go to a High Court or a Supreme Court only in writ jurisdiction, not in an appeal jurisdiction. So that is the hierarchy. Another point that I want to make clear at this juncture is that Central Information Commission and State Information Commissions work in different domains, and there's no intersection between them, which means that State Information Commissions are not subordinate to the Central Information Commission. They work independently. Each State Information Commission is independent of each other and independent of the Central Information Commission. So this is the appeal procedure. Section 20 provides for penalties. As I said, if you don't disclose information and if you unlawfully deny information, then the Information Commission, as central or state, as the case may be, may impose penalty. There is one provision in this section which also provides for compensation, which means that if you have been denied critical information right in point of time or prescribed time, which would have benefited you, but has been wrongly denied to you, and you have suffered certain losses, then the Information Commission, in its wisdom, can award you compensation. I remember a case where a DDA matter, original records, land records were missing. Naturally, detriment was caused to the appellant. I awarded him compensation of I think 1 lakh or something. So this is how it is. Section 22 is has overriding or is about overriding effect of this law on other laws. General impression is that other laws cease to exist qua the RTI Act. This is not so. So long as other laws are in line with the RTI Act, they do not cease to exist. They operate in their respective domains. Only when they are contradictory to, or they are contradictory to, or they are not consistent with the RTI Act, only then and only then they will be overruled. Then Section 24 is interesting. It's about exempted organizations. There is a schedule to the RTI Act which enumerates about 36 or 37 exempted organizations, which means that RTI Act does not apply to these exempted organizations. Now, one very interesting phenomenon, rather peculiar and paradoxical phenomenon, is that the Ministry of Defense and its instrumentalities, Army, Navy, Air Force, they are subject to the law. But paramilitary forces like BSF, which I served for a short while, CRPF, and some other paramilitary forces, this law does not apply to them. Another paradoxical situation is that this law, that the CBI, which is investigating agency, is exempted from the application of this law. But police agencies across the country, which are also investigating agencies, and they are primary investigating agencies, they are subject to this law. So this is the broad framework of law. Now, how the law has worked. Very interesting. First, RTI applications, the sheer volume of work. Data that is available is suggests that from 2005 to 2019, over 3 crore RTI applications were filed in India. Over 3 crore. These figures are not very accurate because the documentation is not very proper, because different commissions adopt different yardsticks, and some commissions do not kind of maintain this data properly. But anyway, broadly, over 3 crore RTI applications have been filed. Central government alone accounts for about 93 lakh applications. Now, RAG, there's an NGO, and NCPRI, another NGO, they conducted surveys in first 2009 and then in 2013, 14, and 2009 surveys become outdated, but the findings of these two surveys are almost identical. Since the topic is mapping the efficacy and efficiency of the law, effectiveness of the law, so I'll briefly mention the findings of these surveys. One, there is a poor awareness about the RTI Act, worse in rural areas than urban areas. 64% people did know about the RTI Act. Two, the participation of women in the RTI process is very low, is only about 8% in Assam and Rajasthan and 4% in Bihar. Three, only 14% applicants were rural and 58% from towns, which means that rural people have not been able to take that much advantage of the RTI Act. Four, 80% respondents in rural areas and 95% respondents in urban areas said they wanted to use RTI Act to seek redressal of the grievances, which means even though, strictly speaking, RTI is not meant for redressal of grievances, but people want their grievances to be redressed through this law because there is no other effective grievance redressal mechanism. In fact, in my book, I have argued that there is no harm if this law is used as a grievance redressal mechanism, because after all, law has to be, is a beneficial legislation. It has to be useful to the population. For lack of time, it's not possible for me to tell you at this stage how this can be used for benefiting the people or as a grievance redressal mechanism in question answer session. If I have the opportunity, I'll explain to you how I did good to some people through this law. So another finding of the surveys is that the applicants from weaker sections of society, they are often intimidated. You know, those who seek information, if they belong to weaker sections, they're intimidated, threatened, and even physically assaulted. Of course, 32 people, RTI applicants, they have been killed across the country. Some, of course, may not be uh, purely because of RTI activity, but mostly it is because of RTI activity. Now, important finding of these surveys is that 49% applicants sought that information which should have been proactively or suo motu disclosed under section 41B. Now, this is very important and I'll dwell on it a bit. I said voluntary disclosures, if they are made, then half of the RTA applications will not be there at all. If that happens, then the workload of the public information officers will be reduced. Likewise, first appellate authorities workload will be reduced, and likewise commissions, information commissions workload also will be reduced, and lot of paperwork would be avoided. This is a very important finding. Surveys also say that there is a poor record management across the country. So another important finding is that 45% of public information officers, they do not have any kind of training. In fact, you know, when people would come to me and when I would ask them whether you are PIOs have read the RTA Act, they would say no, they have not read the RTA Act. Mind you, they are the adjudicatory entities in their own limited way, but they don't know what the law is. They merely go by common sense. So then I would give them copies of the RTA Act, which people would give me. I would say, if you can read English, go through it and try to act according to this, and so on and so forth. Another important finding, and the last one, is that you see, central government can formulate laws under section 27. State governments can formulate not laws, the rules. Central government can formulate rules under section 27. State government can formulate rules under section 28, and the the competent authorities. There are two expressions. One is competent authority and second is public authority. Public authority I have briefly explained to you. Public authority are like heads of departments, ministries, public sector undertakings and so on and so forth. They are public authority. They are liable to give information. But there is another legal concept, section 2E, competent authority. Now, who are the competent authorities? Speaker of the houses, parliament and state legislatures, they are the public authorities. Chief Justice of India and Chief Justice of High Courts are public authorities. Administrators of union territories are public authorities. Now, these competent authorities are also competent to formulate rules. Now, the result is central government formulates rules to implement this act. All the state governments can formulate rules. In fact, they have formulated rules. High courts have formulated the rules. Supreme Court has formulated rules. Speakers, I don't know whether they are made or not, but they are competent. So the result is there's a multiplicity of rules. As of now, there are about 110 sets of rules to implement this law, creating all kind of confusion. So in my book, I have argued that all this concept of competent authority should be deleted from the statute. Only the central government should be the authority to formulate rules for uniform applicability of these rules across the country. So this is broadly about the RAG survey and NCPRI survey. Now, another issue about implementation is the format of the RTI applications and the length. So The law says that law doesn't provide any format. You can write anything anywhere on a slip of paper, whether Hindi or Marathi or Gujarati, so long as a local language or English, and is a valid RTI application. Now, about that I have no problem, but I would have preferred if it has a certain format, so that person seeking information knows what he's asking for, and he's a little more systematized in his script. But length, I have seen RTI applications which run into pages and pages and pages. Now, some states, Maharashtra and I think another state is Karnataka, they have formulated rules to the effect that no RTI application should be of more than 150 words. Central government has also formed rules that should not be more than 500 words, but they said, but no application will be dismissed only on the ground that it contains more than 500 words. So it's neither here nor there. So the word numbers need to be limited, otherwise whole thing becomes unmanageable. Public information officers, they are not law officers, they are not law trained, the quality is poor, and they don't know law, and they had no training, and therefore the law is suffering. First appellate authority, according to me, my experience, first appellate authority is the worst link in the chain, because public information officers, whether they know law or not, at least they're worried that if they don't perform, they'll be punished by the commission. But as far as first appellate authority are concerned, they think that they're law by themselves, and therefore they just don't bother about disposal at all, because they are not punishable by anyone, particularly the commissions, and therefore they are not taking their job seriously. This is my feeling. Information commissions, they are doing their best, but their best is not good or not so good. Why? Because they're heavy backlogs. CIC, Central Information Commission, has a backlog of 35,000 cases. Uttar Pradesh, when I collected data from a book in 2019, it had about 60,000 pending cases. Imagine, 60,000. Maharashtra, 46,000 cases. Then, reason for this is inadequate disposal. In Central Information Commission, we unanimously decided that each commissioner should dispose of about 3,200 cases per year. If this norm is accepted and implemented by all information commissioners, whether the Central Information Commission or the state information commissions, the disposals will tick up and the pendency will be considerably reduced. But it is not being done. So heavy backlog is really breaking the backbone of the information commissions. And therefore, if the decisions come after 2 years, which it happens, like it happens the High Court and the Supreme Court, then the information ceases to be information. It becomes historical document. It becomes history. Now, if there is heavy pendency in the information commissions, equally there is a heavy pendency in the high courts. You see people go in writ jurisdiction, and then they lose track of the things that are happening over there and taking long time. One matter which I referred to in a book, it was decided by Gujarat High Court after 15 years. Suo motu disclosures, as I said, they are inadequate. It's a serious issue because the manner in which Section 4.1b has been drafted, it leaves a lot of vagueness in the whole thing, and therefore it's not possible in the best of intentions for the public authorities to make effective suo motu disclosures. It needs to be redrafted with the help of experts, and it is for the central government to do it. What's not happening because of inadequate suo motu disclosures, the burden on the adjudicatory machinery is very heavy. Vexatious and frivolous applications is a problem. Even though RAG survey says only 1% applications are frivolous and vexatious, my personal opinion is that it's much higher than that. But that cannot be a ground for outlawing these kind of applications, because if these kind of applications are outlawed, then what will happen is PIOs will take the first opportunity of of dismissing them as vexatious and frivolous. So therefore, let it go on. It involves some waste of effort, but it doesn't matter. So commissions, heavy pendency I have talked about. Over the 2 lakh appeals are pending in the commissions. So this needs to be looked into. You see, the increase in the number of commissioners is not the solution. Like high courts, Supreme Court, number of judges being increased every time, but there is no improvement in the disposal of in the reduction of pendency. So this won't work. What will work is that whatever commissioners in place, they should dispose more cases. You don't have to write 20 pages in a case. I personally believe that in most of the cases, 1.5 page judgment is good enough. It can address the core issue and pass a cogent and legally sound judgment. So another problem area in implementation is that commissions do not have authority to implement their own decisions, because the legislature thought that goodwill will prevail and therefore the decisions of the commission will be implemented, but it's not happening. Like I was a member of the bench. In fact, I wrote the judgment. Political parties, I declared them to be public authorities. So this decision was not challenged in the High Court or Supreme Court. It has attained finality, but no political party has implemented it. Some NGOs feel that commissions are reluctant to impose penalties, and therefore they're crying that more penalty should be imposed on on public information officers who are not up to the mark. Well, some penalties should be imposed, but excessive penalties will further demoralize them because they don't get any compensation for the additional work they're doing. But there's some merit in this. But overcrying over this issue is also not uh, correct. Last, not the least, even though the preamble talks of containment of corruption, preamble of the RTI Act, question is whether RTI has contained corruption, reduced corruption. Well, logically, it seems so. Logically, it should contain corruption. But my impression is, and there are no empirical studies, only impression. My impression is that you see what the issues that we have raised in the RTI applications are bread and butter issues. They're not policy issues. And since policy issues are not being raised in the RTI applications, therefore, it has not made much dent. I'll not say it has not made any dent. Of course, after the RTI Act came to being, then whole process, department processes are being, computerized, and all kind of things are happening. But so it has not made that great impact in containing corruption as one would have expected. I think I have overrun my time by 10 minutes. So you're welcome to raise any questions that you have about this law or its implementation. Thank you.
Thank you, sir. Thank you so much. It was truly enlightening for all of us. And our participants have asked some questions. And so if you allow, I will put that question before you. Um, so the very first question is, has RTI put a burden on various government officials to keep a record for everything, which has led them to give less attention solely on their work?
Well, government officers say that their workload has increased, but frankly speaking, surveys show that even though they have extra workload, but not this excess is not much. So therefore, they're only pretending when they're saying that this workload is keeping them away from the routine work. It's a simple work, and the issues involved are not very complicated. If one is methodical and one is working from hard, not only for form's sake, but the workload is not much. It should not. It has not derailed government work, regular work, and it cannot, and it will not. So this pretentious approach of government officers is not factually founded.
Okay, sir. Thank you so much, sir. So the second question is, how can RTI Act be made a tool for the development and upliftment of the weaker section of our country?
See, we say information is power. If this is true, and it has to be true, then this power has to be used or can be used to seek information. Now, regardless of whether you are weaker section of society or your upper class society, it doesn't matter. Now, question is what information you are seeking and whether you are getting this information. So, if information is power, then information can be used for personal growth, individual growth, as also for societal development.
Okay, sir. Thank you so much. So the last question is, how to check gross misuse of RTI Act, such as multiple and repetitive applications or fake addresses?
This is a genuine problem. In fact, two very grown-up people came to me when information commissioners sought an appointment after my office hours, and they came and started weeping. WEEPING. I said, "What's the issue?" He says, "We had some deputationists from public sector undertaking, and he had done his tenure. So we returned him to his parent cadre. He didn't want to go because he found our office to be very comfortable. And now every day he writes a long RTI application. So they told me that we are a research organization. If we spend whole time in responding to the RTI applications, no time will be left with us for doing the real research work." So they started weeping. I said, don't weep, I'll give you a solution. And there's a solution. Very simple solution. It's Ram Ban. Not to be quoted, it has to be kept in use sparingly. Section 7 within bracket 9. Disproportionate divergence of resources. I tell you a practical method. Now, if somebody is seeking information, 10 points, one application, another 10 points, other application, another 10 points, 30 questions he's asking you, 30 pieces of information he's seeking. No, he is not Einstein. His mind can't be so fertile as to make or raise new questions in the future RTI applications that he files. So therefore, the answer is that you have replied to his first RTI, you have replied to his second RTI, replied to third RTI, and 50 RTIs pending. So you say these questions you raised in RTI application number 1, they were responded to so-and-so. Second, we responded to so-and-so. Third, we respond. So we have carefully examined other 27 or 57 RTI applications that you have filed, and you find that the queries raised by you are almost the same. Therefore, our response to first 3 RTI applications may be deemed to be the response to the rest of the RTI applications that you have filed. He has no answer. He can't go anywhere. After all, from where will he bring fresh questions? He's simply harassing you. But don't use it too often. Use it sparingly, because I said Ram Ban. Ram Ban also loses vitality if it is used too often.
Thank you, sir. So I will send some more questions from our participant. So the next question is, what are the measures that ought to be taken to reduce the pendency of cases and strict enforcement of decision of Information Commission?
There are two issues we have raised in this question. One is what are the means of reducing pendency, and second is enforcement of decisions. They're separate issues. As far as pendency in the, pendency at what level? First level is the public information officer. Second is first appellate authority. Commission I'll touch later. See, there's no upper limit on the number of public information officers that the competent authority can appoint. Likewise, there's no upper limit of the first appellate authorities that the competent authority can appoint. So, if there's a high pendency or there's a heavy intensity of RTI applications, then the public authority should appoint more number of information officers and first appellate authorities that will take care. And those who are not performing, they should be given a stick. So it's easy. But information commissions a problem area because the upper limit prescribed in the Act is one Chief Information Commissioner and 10 others, total 11. Now, mind you, Mizoram is a state, Manipur is a state. It can have maximum of 11 hands to dispose of second appeals. Now, UP, population of 23 crores or whatever, whole of Europe, it again can have only about 1 plus 10, 11 commissioners. So Maharashtra, again densely populated. So now, therefore, number can't go on. So therefore, the fixing of limit, in huff and hurry, they did all this. They should leave this discretion to the state governments. If they want to have less numbers, they should have less numbers. They should prescribe a threshold and then leave it to open. UP can have even 20 information commissioners because it's a very vast state, it's a very big state. And Mizoram, well, the number of 10, or Manipur, number of 10 is too high. So therefore, some kind of differentiation has to be made in the workload of the states. This is one. Second, information commissioners, they need to have motivation to dispose. Frankly speaking, I have seen commissioners writing 40 pages on a very flimsy and small matter. If you have reasonable language skills and if you know a bit of law and if you have conceptual clarity, there is nothing that you cannot put down in 1.5 pages. I used to do that. I have heard the appeals. Kya zarorat hai isko likhne ki? Likhe, heard and decided like this. So you can cut down on words so that scriptive work is reduced. And I used to dictate my orders in the presence of people on both the sides because issues are not very complicated. Rare cases like political parties, we reserve the judgment because there are complicated issues involved. Otherwise, issues are very simple. Either you're giving information or you're not giving. And now it has become still easier because case law has developed. Supreme Court, in my book, I have incorporated 36 decisions. High courts, decisions have come on various sections and subsections of law. Now it's become very easy. So therefore, commissions should improve their performance. So commissions are not totally unblameworthy as far as the pendency is concerned. But of course, big states, number of 10 is too small. Implementation, commissions can't do anything. It requires legislative amendment. And these days, you see, as soon as central government tries to touch this law, NGOs, I call them Jolawalas, they start crying. They feel that this law will be diluted. And therefore, this logjam has been there for some time and will continue for some more time because there is a deficit, a trust deficit between the lawmakers and the NGOs who claim that they own this law.
Thank you, sir. So the very last question is, what are the opportunities for law students in RTI?
See, law students look for money. Unfortunately, there is no money in this. So from that limited perspective, law students can't look for anything in this law. See, money is there in I am also running a law firm now after my retirement with my son and all that. So they're simple, you see, it's a low stake litigation. And therefore, litigation, yes. There are parties, yes, but there's no money. So don't look for any career opportunities in this law as a law student. Going for corporate law or whatever. And if you want to really make a name, then criminal law. Other laws are subordinate to this criminal law. You defend a big case and you make a name, or you prosecute a big case, you make a name. Ram Jethmalani, all that, all these people. See, they didn't practice RTI law. It was not there at that time. Only big cases make law, and big cases are really criminal cases.
Thank you, sir. Thank you so much for answering the questions. Now, wrapping up today's session, I would like to invite our faculty convener, Govind Prasad Goyal, sir, to provide some concluding remarks for today's event. Over to you, sir.
Thank you so much, Pataksha. It was very wonderful and highly insightful address by sir. So we are grateful to you. That you have shared a valuable knowledge and experience with our students. And I have jotted down a few of the points as sir has very rightly mentioned, if there is a disclosure of the information, so moto, then it is taking the precedence over the non-disclosure. So whenever there is a disclosure of the information which is available on the on the platforms like websites and all, so it may reduce the workload of the officers who are concerned with it. Apart from it, sir, there is a one actually the question which you also highlighted that there is a poor record of management in the office. And many times, actually, we also filed one application to the MHA, and they said that the most petitions which were filed before 1981 record is not available. So such things are also there in the public domain. So such informations which are not available, and I think that must be also taken care of. Apart from it, even the persons who are assigned with the task of furnishing the information to the information seeker, they are not well trained. So sir has rightly mentioned there must be training of those persons, and they must be provided with the books of law so that they can go through the RTI Act and then execute the things. And apart from it, moreover, sir has said that there is a multiplicity of law rules, and around there are I think 110 rules of different entities they have framed. So that is also causing a lot of confusion. So what to follow and what not to follow. And one more thing that is actually also painful to me, that even the order of the commissions are not having their implementing effect. And even sir has said that the political parties must be held accountable. They must be also coming under watchdog of this RTI. But yeah, there is no implementation as such. So it was highly insightful and enriching session, sir, which you have delivered to us. We are thankful to you for your time and for the experience which you have shared with our students. Thank you so much, sir.
Thank you. Thank you, Professor. Well, thank you.
Thank you, sir. Thank you so much. And today we were blessed to have such a wonderful guest who enriched our life with a share of knowledge. And to thank them, now I would like to call upon our student head convener of our IMS RTI Club, Mr. Pulkit Rehan, to present the vote of thanks.
Can you tell me what does this IMS stand for?
Sir, Institute of Management Studies, sir.
Institute of Management Studies. So it has management, this thing, teaching, and then law, and what else?
We have, sir, IMS Noida for management and other courses, and we have IMS Law College also.
Sir, actually, so we have got.
You are from law college or from management, this thing, or both?
Actually, we are having, sir, two colleges. One is dedicated to law studies, and other is having other stream courses like journalism, management, and IT. So it is a sister branch of Institute of Management Studies.
Okay. Yes, sir. Somebody was saying something. Yes.
Yeah, Pulkit may continue, please.
Okay. Thank you, Pratiksha. Thank you so much, Shri M.L. Sharma sir, for accepting our proposal and gracing this event. Thank you for sharing valuable knowledge on right to information topic. Thank you so much, sir. Thank you to the Honorable President IMS Noida, Shri Rajiv Kumar Gupta sir, for giving us this platform. Thanks to CMD Shilpi Gupta ma'am, Senior Director Dr. Kulni Suri ma'am, Dean Academics Dr. Manju Gupta ma'am, Dean Law Dr. Satya Prakash Garg sir, Program Coordinator Law Professor Bhavna Arora ma'am, Faculty Convener Professor Govind Prasad Goyal sir, and of course thanks to the IT department. Thank you Santosh sir for arranging everything. Thank you Utkarsh for all the coordination, and I'd like to mention I am proud of my team. Thank you so much Pratiksha for anchoring this event. Thank you Satyam Kumar and Aryan Gupta for moderating today's event. Thanks to the entire core committee team of volunteers, members. Thanks to Nandini Singh, Lipi Sharma, Ajit Masal, Jatin Sharma, Amreen, Ambalini Chaurasia, Prachi Kumari, Annu Kumari, Amaya Sharma, Saikat Gangopadhyay, Swati Mishra, Prerna Singh, सत्या कुमारी, काजल मेहंदी रफ्ता, क्षितिज शर्मा, हिमांशी कपूर, शांतनु उपाध्याय, अक्षिता त्यागी, प्रखर शंकर, उत्कर्ष झा, सलील शर्मा, हर्षित कुमार, संस्कृति सना, आकाश, तन्वी सिंह, गरिमा वर्मा, श्रवण कुमार, and especially thanks to all the participants for joining. Thank you.
Thank you. Thank you, everyone. Thank you,
Thank you,
Prakash.
sir.
Thank you so much,
Thank
sir.
you once again, sir. We don't
Thank
have words to say thanks to you because it was so much enlightening, sir, that we don't have, because the things which you have shared that came from the horse's mouth, from the very source, or from the insider's perspective. So that was really too much enriching to us, sir. And we don't have words. Whenever, sir, it is feasible for you or convenient, and we would like to have your presence in the physical setup of IMS Law for this, sir.
Anytime, anytime. Thank you.
All right.
I'm always
Thank you so much.
available.
Thank
And
you so
read
much.
my book. It's going to come out. So you
Thank
won't
you
have
for
to
accepting.
Thank
All
you.
right, sir. Thank you. Thank you.
Thank you so
Thank you
much.
so much, sir. And thank you
Thank you.
everyone for joining. The session is concluded.
आप Thank you. चलिए बंद कर दीजिए.